So, since the last time that we've updated, the Supreme Court has denied Kohberger's appeal. Official docs reveal prosecution's use of law enforcement against defense again, sparking due process debate.
Idaho Supreme Court has denied Bryan Kohberger's motion for permission to appeal from a lower court's judgment.
I know you're absolutely shocked that those, like many other documents, were sealed. Oh wait, you're not shocked at all because that happens all the time? That's right. We're going to unpack these developments, shed light on some complex interplays of legal strategies, and the critical role of transparency in a case, a defendant getting a fair trial, change of venue motions, and what they pertain to in Idaho. And wham bam, we have another weird one for you because the Idaho Fort never stops serving up the weird. This case is insane in the membrane sometimes, dragging law enforcement and FBI into pretrial issues.
Ann Taylor told Judge John Judge that she would file a motion regarding what happens to witnesses after they testify in court. Latah County Prosecutor Bill Thompson explained why he asked the FBI to investigate after hearing Vargas might be questioning some of her own testimony.
This isn't the first time that it's happened. Yet again, we have law enforcement involvement in the pretrial issues of prosecuting attorneys and defense attorneys for the Bryan Kohberger versus Idaho case. So we all remember that prosecution was extra miffed about the change of venue motion. And the judge seemed to indicate that he definitely didn't want to move it out of the county.
The judge will consider, we now know, at a hearing set for March 14th, but we have early indications that the judge is not leaning towards moving it to another county, he said in the hearing.
So let's do a tiny rewind and check out what prosecuting attorneys were miffed about and what they pointed out specifically themselves, which they'll eventually argue in their own motions, as confusing as that sounds.
There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. Judge, there's been a lot of publicity.
There are other considerations besides just the massive amount of media and an impact on potential jurors.
Now, despite the fact that defense attorneys recently made them aware that this change of venue would be coming, and then of course we got an actual hearing date for the change of venue, they should have expected that defense was obviously doing change of venue work. In an odd duck move, prosecution plays dumb to this and pretends that they had no idea it was defense attorneys. If you ask me, they kind of prove the fact that Latah County is biased against this particular defendant. After receiving phone calls from the surveyors doing the defense change of venue surveys, Latah County residents actually reported these phone calls to prosecuting attorney and local police. In fact, they had one of these residents record the entire survey and turn that in. And they also filed exhibits which included the written testimony of another person who had received the same survey. An investigator which everyone will be pretty familiar with in this case is Brett Payne, and it appears that Brett Payne completed an investigation for the prosecution pertaining to these surveys that were being given by defense. And prosecution's response to this during the entire filing kind of indicates that it didn't know, and then eventually it kind of finally gives defense attorneys a phone call right before they would turn around and ask the court for an order preventing defense from doing said surveys. Now, prosecution claims that they originally got this complaint from a citizen on March 8th, and they didn't actually contact defense attorneys until March 19th, apparently. Defense and prosecution meet and they discuss the matter. To Bryan's side of the case is concerned with due process. The procedural event which occurred didn't allot him a reasonable notice and attempt to be heard. Therefore, a hearing which would include witnesses and the opportunity to argue against what the prosecution was motioning for. The state has alleged that the defense has violated this court's revised order. Specifically, they write that they are aware of these prohibitions, and in fact, they wrote these prohibitions, and the defense is not disclosing information. The defense is asking prospective jurors in the county of Latah as to what information they are aware of that was previously disclosed vis-a-vis the press. Further, the revised order allows for counsel to ask questions of the public to do its work. That is exactly what happened, they claim. And the relevant case law factors in prejudice pursuant to the State versus Haddon. This is a case in the Idaho Court of Appeals that outlines relevant factors a court must consider when taking up a change of venue motion prior to attempting to seat a jury. Extensive publicity, accuracy of publicity, and the size of the community from which the jury would be drawn. Now, this court referenced the size of the county as being small, claims defense, and this fact alone does not require the presumption of prejudice, nor would such a rule be practicable given the relatively rural nature of many of Idaho's counties.
There are other considerations besides just the massive amount of media and an impact on potential jurors.
It goes on to point out that the Haddon court said that parties challenging venue must bring, quote unquote, more than the size of the community. Certainly, pervasive media coverage that continues to this day is a factor and will be discussed in later filing. The focus here is critical survey work obtaining information to support the change of venue motion by establishing that, quote unquote, more. The defense has hired Bryan Edelman, owner of the Trial Innovations Company, conducting this survey. Dr. Elderman will apparently be testifying probably by Zoom, as we can see from the recent court filings from the defense. It's likely, defense goes on, that it will help to understand how surveys are done in cases such as this. The survey, to be valid, must be done by a random selection of contacts. The number of surveys are small, but enough to see trends that are attributed to a larger population. Media influence questions are not, capitalized not, factually correct. That is exactly the point. That is what Haddon Court said in relation to extensive media coverage. Non-factual media dissemination is more harmful. It would be of little use to this court to know that there was a deluge of unobjectionable media coverage. The only way for this court to have a way of understanding what the parties would face with a juror from Latah County is to know what they are being exposed to. As Dr. Edelman can testify, that is the sort of work that parties do in these cases. It may be new to some in Latah County, but it is still the industry standard, professional, and ethical way to do this work. There is no realistic possibility that this will affect the jury selection in Latah County. The problems with this county are not of the defense's making. They are what the defense wishes to expose for this court. In their conclusion, they state the state's motion is filed against the backdrop of Mr. Kohberger preparing for his motion to change venue. The state objected to the court scheduling a change of venue hearing, and now, through this motion, it's thwarting the defense's preparation for the motion. The state knows counsel for Mr. Kohberger did not violate the revised non-dissemination order. The state and counsel met the day before the state filed its motion. The state's motion should be denied, and the order prohibiting future contact with prospective jurors should be withdrawn. In their motion to rescind order for failure to provide due process, they write, on March 22, 2024, late on a Friday afternoon, the state filed its motion to prevent contact with potential jurors. The motion included attachments. The late Friday afternoon filing was a strategic action by the state. They wrote, the state was well aware of the survey taking place long before its late filing, March 22, 2024. Reading the state's filing, it is clear that the state was aware of the survey process by March 8th. The state reached out to defense counsel on the 19th and scheduled a meeting for the 21st. By the time the parties met on the 21st, the state had at least one transcript of the survey and knew the questions that were asked. At no time during the 13 days between the 8th and the 21st did the state determine an emergency existed or must be brought to the court's attention. Surveys such as these meet the standard of care required of the defense in a capital case, yet the state told the defense it wanted to tell the judge about this. The defense agreed to attend an on-the-record in-chambers meeting to discuss defense work being done. The state chose not to wait. Counsel asked the state to refrain from giving these attachments to the court prior to the meeting where the defense could be heard because the court may take an action, thus prohibiting Mr. Kohberger an opportunity to be heard. Unfortunately, through its letter writing to the court, the state has achieved previous action without Mr. Kohberger receiving due process. The state knew what it was doing when it filed a late afternoon motion with attachments. They go on to say that they filed an objection and asked to later submit more information on the matter, but the court went ahead and issued an order halting defense work without giving an opportunity to be heard. They go on to claim how this is a constitutional violation and that the opportunity to be heard did not occur and that the proper due process requirement had not been satisfied. They go on to say that at a bare minimum, there must be some process to ensure that an individual is not arbitrarily deprived of their rights, and for the court to take action without ensuring Mr. Kohberger has an opportunity to be heard stops the defense from meeting its deadline and burden pertaining to filing for that change of venue. And come on, guys, the decision to engage law enforcement to investigate the survey, I think on the lower end of the spectrum is at the very least, disproportionate to the perceived threat. I would question whether this move is genuinely aimed at protecting impartiality or whether it's basically a tactical decision, placing additional pressure on defense, potential witnesses, and creating an atmosphere of scrutiny and suspicion around prosecution's activities. Serious concerns with respect to FBI agents showing up to Vargas's house. That's right, we gotta rewind here to understand the full scope. Not only has it been a hot minute since all of this stuff has been discussed, but with the recent gauntlet, I feel like it's important to go over all of these particulars when it comes to all of these accusations about prosecutorial misconduct in this case.
Toss his grand jury indictment.
Kohberger's attorneys say that the grand jury was given inaccurate instructions, and they also wanted the indictment thrown out due to what they're saying is a biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct.
So here, not only are we going backwards to understand truly the scope of prosecutorial use of investigators against defense's efforts in the Bryan Kohberger case, we're going to be highlighting some of the same old concerns that we've had with the case from the get-go, such as coercion concerns, an action taken upon prosecutorial attempts to coerce or influence further testimony, and potentially intimidating the witnesses, witness tampering with experts that defense had put on the stand. As mentioned, not only does this rewind back, but it ties into what I want to mention to everyone, why you should care about the Bryan Kohberger case and why it pertains to all of us. So chicks and dudes back in the day were all like, yo, guess what? In the future, we're going to have this whole DNA database, and the fact that there are no laws and regulations surrounding its use, it's going to be a free-for-all with law enforcement. But everyone was all like, oh, conspiracy theory, tinfoil hatting it again. But now here we are with this public database, which was used in the Bryan Kohberger case. Not only was this public database utilized in order to identify the alleged perpetrator of the Idaho 4 crimes and defendant in the case, Bryan Kohberger, but also his case kind of opened the public's view about something that's really important, and that is data breaches on GEDmatch, GEDmatch.com. This is a third-party site that lets everyone who has taken their different genetic company and gotten themselves a nice little cute ancestry workup from that company. Well, you put your information on this website and it consolidates everyone's data without leaving out those that have used a company that you didn't. So you can get your matches that are on 23andMe if you did Ancestry.com. Well, during Vargas's pivotal testimony, she talked about a backdoor method that law enforcement was utilizing in order to purposely avoid the scarcity of opt-in genetic profiles. That is to say that they wanted to avoid all of the people who had opted out of police investigative genetic databases. They upload their information and they opt out of the use by law enforcement. Well, they're thinking that they're following the terms and conditions and that obviously their data is not being breached. However, it was. Thankfully, due to vigilant eyes on this case, the company that owns GEDmatch allegedly corrected this backdoor method. However, a method that has still not been addressed is FBI or other investigators using the public database. So just uploading an S&P profile, the same type of genetic profile which you are sending off to Ancestry or that investigators are utilizing for investigative genealogy, genetic forensic work.
you going to perform oral sex on him for a loan?
No, I wasn't.
Yeah, you are. We heard everything you said. He's an undercover police officer. He's not Coco the Clown.
Cop versus cop.
Now Detroit Police Internal Affairs are investigating a huge and dangerous mistake.
They were about to bust their own undercover officers, posing as dealers.
They appear to be like Keystone cops. I could not agree more. Very embarrassing to this organization.
You were doing a prostitution deal with this guy.
He's a cop.
What do you think?
Yeah.
All right.
You got really white teeth, man.
Well, there you go.
I know you guys get the best dental work.
Is it the best?
Yeah, I think so, man. As a city employee.
Go, go, go.
Police! Police! Yeah, go move! Man up! Go move!
Watch out.
Police!
Required to show a proof of driver's license.
I'm not operating a vehicle. I'm sitting in a parking lot.
Well, I'm gonna be here all day. Okay. So if you want to go down that route, we can go down that route.
I don't want to go down any route. And I'm shaking because I'm angry because I shouldn't be policed while I'm sitting in a parking lot doing nothing, smoking a cigarette, waiting on my friend to see if she can print out her ticket or not.
And that's what I'm trying to figure out what's going on. That's all I'm doing.
Am I free to leave? Am I free to leave and go inside of the Greyhound station then and go away from this conversation?
Yeah.
Thank you.